Let me see if I carry it. Hi guys, soyez bienvenue. Welcome back to Battle with Ola. This is Mujola Olua and I'm so thrilled to have you here today. Today we want to talk about Volenti non-fit injuria. Volenti or Volenti if you like, non-fit injuria. You know, in Latin, in real Latin, you know, the V is pronounced as W, so you have Volenti, but let's just call it Volenti non-fit injuria. It's a Latin maxim and it's a defense, you know, in law. It means that if you're consenting to an injury, that is, you are voluntary, that's where volenti is from, you cannot claim, you know, the benefit from any such injury in the future. So for instance, if you have consented to the doing of an act, you cannot object to the damage or the injury that results from that act. That's what it means. Pardon the noise in the background. Volenti non-fit injuria just means that if you have been consenting, you know, to the doing of an act, you cannot then cry wolf concerning the injuries that result from the doing of that act. So for instance, a boxer cannot claim damages, you know, for injuries sustained during boxing, or he cannot come and say that, hey, my neck, oh, my head, oh, they boxed me, because you're a boxer. You understand what it means to be a boxer. So if you get into the ring and someone pummels you, you cannot come back and now say that, oh, they assaulted me or something. No, that's not to mean that, you know, that everything that results from that act is protected under the law, but we're going to talk about it in detail. But that's the basic meaning. So let's continue. So if you deliberately place yourself in harm's way, knowing and understanding, you know, the likely harm that is probable, you know, to result from placing yourself in that position, you cannot come back and claim in tort. You cannot come and say that personal injury has been done to you, for instance, when you know what, you know, that singular act of yours entails or could result into. So for instance, if a patient has taken himself or herself to the hospital and has consented to, you know, a medical or surgical procedure, they cannot now claim damages and say that, oh, they cut open a part of their body or something. You know, they cannot say that. Although the law will protect, you know, other things that are not necessarily the ordinary results of such an act, the law would protect. But the law will not protect you against, you know, what is supposed to be the ordinary course of events when you were consenting from the beginning. So like the boxer example that I gave, a boxer cannot claim injury for you know, for beatings on their done to their body, you know, in the process of boxing. But we all know that we box with hands, yeah, and gloves. So if the opponent now comes with an iron bar and hits them in the boxing ring, they can claim an injury, because eating or being hit with an iron bar is not within the contemplation of a boxer or boxing ordinarily. It's not a natural course of events, and it's not even a legal course of events. So they can claim for that, but they cannot claim injury for ordinary boxing, like, oh, they boxed me, you know. So that's how to understand or differentiate it, so that you don't create a situation whereby, you know, someone is completely protected, you know, from even unlawful acts they are doing to the other person just because of volenti non-fit injuria. No, the law would not do that. If as a landlord, for instance, you have consented to a tenant living in your property and the tenant has paid you, you know, money for value, the value, that's the possession that they have, you cannot come and file a trespass suit against them, because they are lawfully your tenants. The implication of that is that they have possession of your property, not ownership, but possession. So you cannot sue them for trespass, no, because you have consented to them coming into your property and taking possession, you know, for a period of time. The same way someone that has gone to the hospital for a person for a surgical procedure. So if the doctor trespasses on your body, you know, maybe tries to molest you in a way, even though you consented to the surgery, you can claim for the molestation, because it's different. Things that are not the normal procedure for surgeries resulting in harm to you can be actionable, yes, but the things that are the ordinary course of events of the surgical procedure that you've consented to are not actionable. Volenti non-fit injuria is a complete defense. So if you're a defendant, you've been sued, and it turns out that the person that sued you actually understood what they were getting into and fully consented to all the implications that they are now claiming for, or claiming against you, you can come under the defense of Volenti, and it will be a complete defense to you. But you must establish to the satisfaction of the court, and the court must be convinced that, one, the person understood what they were getting into and they fully consented to it, and they, waived all their rights to a cause of action or to actioning whatever injury resulted from what they were getting into. Of course, not an illegal agreement. The court will not enforce an illegality, so you should always remember that. The key thing to look out for, whether you're a claimant or a defendant, is informed consent. So you need to understand, did this person understand what they were getting into, and did they, expressly or implicitly waive their right, to claim for the damage or the injury that is resulting from what they agreed to get into. So that's very important. In Tichenor and British Railway, for instance, a girl got onto the railroad or rail tracks, and then she was hit by a train, and then she sued, and the railway claimed Volenti, and the court held that yes, the railway had taken adequate measures to protect people from the railway tracks. That's occupier's liability in a sense, and a person that gets onto that rail track after such protections and measures have been in place cannot come and claim an injury has been done to them, because they should understand that you shouldn't even get onto a rail track. It's crazy, but the things that people sue for. Before it was even possible for you to claim Volenti as a drunk driver if someone gets injured, after accepting a lift from you, but it's now been ousted by statute. So before, if you accept a lift from a drunk driver, it is assumed that you understand what you're getting into. He is drunk and you consented to being driven by him. So I just want to use that. It's already ousted by statute. So many other things come into play, but I just wanted to use it as an example for you to understand what Volenti is really about. So essentially, Volenti non-fit injuria is a complete defense in torts, personal injuries, actions for personal injuries generally. So it's a complete defense, and what it says and what it means essentially is that someone who knowingly and willingly risks danger cannot recover for resulting injury. So if you knowingly and willingly risk danger, you cannot recover for any resulting injury. Let me also mention the case of Smith and Charles Baker. It's an old case. In that case, an employee often complained to the employer, that while he was working, rocks that were being carried by cranes, over the work site used to drop on them, used to eat them. So the employer did nothing about it, and then, one day the rocks really hit the employee. He got injured, and then he sued. And then the employer now claimed Volenti, saying that they knew what they were getting into by agreeing to work on the site where, rocks were being moved. But the court held that no, the fact that they agreed to work in that workplace does not, excuse the employer from providing, safe working conditions. So sometimes Volenti often overlaps into occupier's liability and employer's liability. We'll talk about that in other videos, but they can be differentiated. So the court will not just award or agree to the defense of Volenti just because someone knew or maybe had a foresight of the harm that could result, when the defendant could have also prevented that particular injury. So for instance, conversely now, if you go watch football, it is assumed that you understand that if someone plays the ball and it goes off and comes onto the stands and hits you on the head, they can claim Volenti. The football organizers or the players or whoever you're suing can claim Volenti because it's understood. There's actually a case about it. In that case, someone went to watch a car race, and then there was a collision between two cars. One of the cars flew, onto the stands and hit the person, caused an injury. They sued, and the court held that, Volenti will hold, because by buying tickets and going to watch, such sports, you're agreeing, to any resultant injury. So it's a very interesting defense. I'd like you to read up on it, and if you've if you have used it before and it's worked for you, or if it's been denied you in court, please let us know in the comment section. There are, however, a few defenses to the defense of Volenti. There are some things that the court will consider and say that no, this will not hold for you. And I've talked about employer's liability, for instance. Then another one is occupier's liability. That is, you're supposed to keep your residence or your supermarket or your store or your car park or something safe enough, for people that are coming. For instance, safe enough for people that are coming onto it, for business or for visit, such that they don't suffer injury. So the court will differentiate all these things. There are a few exceptions, however, to the defense of Volenti. It's a complete defense, but there are a few exceptions where it will not hold. I think I've mentioned some of them in brief, but to go over them again, one is illegal consent. In a case, a man, raped an underage girl, and he was claiming that she consented. The court held that ordinarily a minor cannot even give consent. And in R and Donovan, it was held that consent to illegality cannot be prove Volenti. So even if someone consents, you cannot, as a defendant, come and claim Volenti because they consented to an illegal act. No, the court will not enforce an illegality. If, for instance, you sleep with a minor and then you're sued or you're tried in court and you're claiming Volenti because the minor consented. One, a minor cannot even consent under the law. So Volenti will not hold for you. Then two is breach of statutory duty. I've talked about that, occupier's liability, employer's liability. If by law you're supposed to do something and you do not do it, and a party sues you and you're now claiming Volenti that they understood what they were getting into. No, the presumption is that even though they understand what they are getting into, you should also do what you're supposed to do by law. Volenti will not hold in that instance. Another exception is a rescue situation. In Ains and Arwood, for instance, someone left their horses unattended, in the street. Someone threw a stone. The horses started running. Some children were playing, nearby, and the horses were going to run them over. So a policewoman, a constable, ran and tried to save the children from being run over by the horses. And then she sustained injury, and then she sued the horse owner. And the horse owner was claiming Volenti, that she should have known that by dabbling into that kind of situation, she would be injured, and that she was even doing her duty as a policewoman. No, the court held that even though she was doing her duty as a policewoman, you as the horse owner, you should know not to leave your horses unattended, in public places. In another case, a doctor ran into a fire, to save some people, even though it was warned that he might be suffocated by the bad air and that he should wait for rescuers to actually come. He died in the process, and some other people died. And then when the case went to court, the court held that even though he was warned and he knew the danger he was getting into, that was bravery and an act of kindness to mankind. So Volenti will not hold for the defendant in that case. Another exception is negligence. In Braddon and Osborne, for instance, a husband and a wife, they went to eat at a restaurant. The restaurant skylight had broken, and then while they were there, it fell down into the house. So it fell down into the house and injured the husband. While the wife was trying to help him, she was also she sustained a strained leg, So both of them were injured, and when they sued, the court held that that's negligence on the part of the owner of the facility. So Volenti will not hold for the owner because he should have put his place of business in proper conditions for the patrons, even if they knew that the skylight was broken or something. He would not be protected by law because he should have fixed it. So, and then act of God is another exception to the defense of Volenti non-fit injuria. So if you're claiming Volenti and it's an act of God, it will not hold. Unfair contract terms is another exception, one more exception. Unfair contract terms. So if you have a contract with a person, and because you have already preempted what could happen, you now put a clause in the contract excusing or exonerating you, from responsibility for some things, and then there's a damage, the person sues, and you're now there's a damage, the person sues, and you're now claiming Volenti that, oh, I've already put that clause in our contract too, so you should have known. The court will not enforce that for you if that term is unfair. So the court will consider it. This term that you put, this exonerating clause in the contract, is it fair to this person? Even though they read it, they knew it, they signed it. If it's not, ordinarily, the court would not hold Volenti for you. So there are a few other exceptions, but I'd like to pause here. I want you to read more on it, and I want you to leave me comments in the comment section to continue the conversation on Volenti, non-fit injuria. I just mentioned something, act of God. We're going to do a video on that as well, and I hope that you would watch it. As always, I will see you in my very next video. Don't forget to subscribe to those.